Hello, welcome to Legal Brain. Today I'm going to take an introductory class regarding Introduction to Law of Contract, in which I will be explaining you about the basic things of contract, like what do you mean by a contract, which section speaks about contract, what do you mean by agreement, what do you mean by enforceability, and what do you mean by, the basic essentials of a contract. So you can look into the screen and can listen to the class. So the law in India concerning law of contract is dealt under Indian Contract Act 1872. So this is the act in India which speaks about contract and general principles of contract. And this particular act, it's an early enactment which is very old and which came into force in India in first day of September 1872, and which is based on New York Draft Code, and which we have basic the general principles of contract, like what is contract, what is agreement, what is offer, and all this definition and essentials of contract. So in this class I'm going to teach you what do you mean by contract and what do you mean by agreement. Look into the screen. So I'm going to give you a very simple definition for contract. What is contract? The term contract has been derived from a Latin word contractum, and the meaning of that particular word is drawn together. So what do you mean by drawn together? Example, there should be minimal of two parties to the contract. Example, myself and you, we both are the parties to the contract. We two persons are entering into a contract. We are called the parties of the contract. And we both are drawing together. We are drawing together a contract. So contract means, the Latin term meaning is drawing together. So for that, there should be minimum of two parties to draw together the contract. So other than this particular meaning, there is a valid definition for law of contract, and that is mentioned under section 2H, 2 subclause H of Indian Contract Act gives the definition for contract. So you can look into the screen. So what do you mean by section 2H? Section 2H says that a contract is an agreement which is enforceable by law. So there should be two elements. A contract is an agreement. Agreement should be there. And the second is enforceability by law. So we're going to learn in detail what do you mean by an agreement and what do you mean by enforceability by law. So for the time being, the definition section 2H says about contract. And there are many scholars who gives definition for contract. One of the scholars is Pollock. He gives a definition for contract, and he says that every agreement and promissory law is a contract. He gives a definition for contract, and he says that every agreement and promissory law is contract. That is a definition given by Pollock. Other than that, there are many scholars who give definition for contract, and one is Halesbury's Law of England definition for contract, which is very important in law of contracts. So you can look into the screen, says that a contract is an agreement. I told you, according to section 2H, a contract is an agreement between two or more persons. I told you there should be a minimal of two persons, like myself and you. We both are the parties to the contract. There should be minimal of two parties, which is intended to be enforceable by law. So we're going to learn what do you mean by enforceability. So enforceability means it should be valid in the eyes of law. That means it should be a legally valid agreement or a legally valid contract. For example, we are entering into an illegal contract, like we are planning to set a bomb in a particular place and we are entering into an agreement, or we are entering into a contract. Is that a valid contract or a valid agreement? No, it is not a valid contract, or it's not a valid agreement. We call it as illegal agreement or illegal contract. So a contract should not be illegal in nature. It should always be legal in nature. And if it is legal in nature, we can enforce it through court of law. Like, for example, we enter into a legal contract, a legal agreement, and I made a breach of contract. Breach means a violation. I made a violation to the contract. Can you file a case against me in court? Yes, you can file a case against me in court because it is a valid contract and it is valid in the eyes of law. And if I am making a violation or if I am making a breach, you can file a case against me. So that is the meaning of enforceability through court. Imagine if it is an illegal agreement, can you file a case against me? No, you cannot file a case against me because that is not a valid contract, which is an illegal contract. So enforceability is very essential in a contract. And look into the definition. And is contracted by the acceptance by one party of an offer made to him by the other party to do or abstain from doing some act. That means one party should give the offer. For example, I am giving you the offer and the other party should accept the offer. Like you are accepting the offer. So there should be two conditions. An offer should be there from one party and acceptance should be there from the other party. So this is the definition which is given by Halsbury Law of England. So now I am going to analyze this particular definition that we already learned. So there should be minimal of 3 essential conditions. First one is a contract is an agreement made between 2 or more persons. Like there should be minimal of 2 persons. Second point is the agreement should be of enforceable through court of law. The agreement should be valid in the eyes of law. That is the meaning. Third point is there are mainly 2 elements. The first one is an agreement. There should be an agreement. Second one is it should be enforceable by law. So these are the, analysis. This is how we could analyze this particular definition. And I'm going to give you a very simple equation for that. That is, contract is equal to an agreement plus enforceability by law. So we can conclude it as if there is a contract, there should be an agreement and it should be enforceable by law. Now, we have already discussed about enforceability of law, and it says that only an enforceable agreement becomes a contract. No other agreement becomes a contract. That means only an enforceable agreement. That means only a legally valid agreement becomes a contract. Next, I'm going to tell you about agreement. We studied about what is contract, which section speaks about contract, what is the definition of contract, what are the elements of a contract. Now, I'm going to teach you about agreement. What do you mean by agreement? Section 2, subclause E of Indian Contract Act speaks about agreement. So you can look into the screen. Section 2E says that every promise or every set of promise forming the consideration for each other is an agreement. So this says that there should be a promise or a set of promise and there should be consideration for each other and then it is an agreement. So there are mainly 3 aspects, or like promise should be there or set of promises should be there. There should be consideration and it turns into an agreement. So we are going to learn in detail what you mean by agreement. So by learning the definition section 2 subclause E, we can conclude that there should be 2 aspects or 2 elements. The first one is offer or proposal. So students, this word offer and proposal, which is of the same meaning, just that in Indian law, we use the word proposal and in English law, we use as offer. So the second one is acceptance. So there should be offer from one person to the other person, like I am giving you an offer, and there should be acceptance from you to me. So offer plus acceptance should be there. So again, I'm going to give you an equation that says that an agreement is equal to offer plus acceptance. So this is a simple equation which speaks about agreement. And what do you mean by an offerer or a proposal? Offerer means the person who is making the offer. Like example, I am giving you an offer. So myself, I am called as offerer or a proposal. And you are giving me the acceptance. So you are called as offeree. Okay. So myself, I am the person who is giving the offer. So I'm called as offerer or proposer. And you are the person who is accepting the offer, and yourself, you are called as offeree, offerer and offeree. So now I am going to explain about section 10, which is very important section under Indian Contract Act, which speaks about the essential conditions for a contract. So section 10 says that all agreements are contract if they are made by the free consent of the parties competent to contract for a lawful consideration with a lawful object and are not hereby expressly declared to be void. So this is the definition of section 10. And section 10, which speaks about the valid essentials of a contract, what all essential conditions should be fulfilled to make a contract. So this definition says that all the agreements are contract if there is a condition, there should be free consent of the parties, there should be lawful consideration, there should be lawful object, and it should not be legally expressly declared to be void. It should not be something which is expressly declared to be void in the eyes of law. So that is section 10. So we can analyze the section 10 into three major points. The first one is that the agreement should not be a mere social agreement or a mere domestic agreement. For example, social agreement, like, you are entering into an agreement with your friend or your colleague, which is termed as a social agreement. And domestic agreement, for example, you are entering into an agreement with your parents, that is a domestic agreement, or an agreement between a husband and wife, that is a domestic agreement. So these kind of agreements should not be, according to section 10, which says that it should not be a mere social agreement or a domestic agreement. Second point is that social or domestic agreement does not give rise to a contractual obligation. Obligation means duty. It should not give rise to a contractual duty or obligation. And thus, such agreements are not enforceable through court of law. So social agreements and domestic agreements are not enforceable through court of law. So based on all these points and all this definition that we learned, there is a landmark case law which is very important in law of contract, and that is Balfour versus Balfour. And this is a landmark case law which speaks about section 10. And I'm going to explain about the facts of the case. We can look into the screen. The fact of the case is that there was an husband and a wife, and they were residents in Ceylon, and where the husband was employed, and they both went to England for a 9 months vacation for leave. The husband and wife, they went to England. And at the end of the time, the husband had to return alone back to the resident place, and the wife was left in the England, in particular place called England. And the husband agreed the wife and promised that he will give up, a maintenance amount for the wife. And what happened? The husband promised to send her a maintenance allowance of 40 pounds a month until she returned to Ceylon. That was a promise given by the husband. And what happened? The husband failed to perform his promise. That means he didn't give the money. He didn't give the maintenance amount, that is 40 pounds to wife. And what did wife do? The wife filed suit to enforce the promise. The wife filed a case against the husband to get the maintenance money. And it was held by the court that there was no binding contract, but only a mere domestic agreement. So we already learned what do you mean by a domestic agreement. What do you mean by that? Like the agreements that we, like for example, the agreement that husband and wife, they're both entering into an agreement, or you entering into an agreement with your parents. These kinds of agreements are having a nature of domestic agreement. And we already learned that that is not enforceable through court of law. So the Balfour and Balfour, Balfour versus Balfour case, it was not binding contract, but it was mere a domestic agreement. And the court dismissed the suit filed by the wife, stating it was mere a domestic agreement and which is not enforceable by court of law. And the court gave a judgment and stated that, see, it is a very leading, it's a leading English case law in law of contract, and says that it was held that there is a rebuttable presumption against an intention to create a legally enforceable agreement when the agreement is domestic in nature. And it says that if it is a domestic agreement, there is a rebuttable presumption that there is no duty, or it's not duty bound to do that, or it is just a mere domestic agreement and which is not enforceable through court of law. So this is a judgment which is given in Balfour versus Balfour, and that is a very important landmark case law under the definition section 10 under the valid essentials of contract. So today we have learned about what do you mean by contract, the definition of section 2H which is given in Indian Contract Act, what are the elements of a contract, what do you mean by agreement. We have learned section 2 subclause E of Indian Contract Act. What are the elements of an agreement? What do you mean by offer? Who is an offerer? Who is an offeree? What is section 10 of Indian Contract Act? And what is the landmark case which is falling under section 10? That is Balfour versus Balfour case law and the facts and judgment of this particular case. So thank you for listening to Legal Brain. In next class, I'll be coming back with yet another important topic. Thank you. Do subscribe to the channel. Thank you.